Today's story is about a simple question with a big consequence. When do we actually have a contract to sell a house? The story, Cochran v. Norkunas. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. Back in the 2000s, the Cochrans wanted to buy a house in Maryland. They found the home they liked, owned by a man named Norkunas. The buyer and seller talked about the price and other terms. Their real estate agents helped draft a document called a letter of intent. The letter of intent listed the property, the purchase price, and other basic terms. But it also said that a more detailed formal contract would be prepared later. The Cochrans thought this letter of intent meant, "Great, we have a deal." They believed the seller was now bound to sell them the house. But things changed. Before any formal contract was signed, the seller backed out and decided not to go through with the sale. The Cochrans were not happy. They went to court and asked for specific performance. They wanted the judge to force Norkunas to sell them the house. Their argument was simple. The letter of intent is already a binding contract. So the key legal question became, was this letter of intent a final contract or just part of negotiations? The Maryland Court of Appeals said there was no enforceable contract. The court explained that to have a contract, you need more than just talking and hoping. There must be a manifestation of mutual assent, a clear, objective sign that both sides intend to be bound now. Here, the letter of intent left important details open, and it pointed forward to a future formal written agreement. A reasonable person would see it as a step in the process, not the final destination. Because the essential terms weren't fully settled, and the parties clearly expected another contract, the court ruled that that letter of intent was not a final deal. The result, no contract, no specific performance. The seller was free to walk away. Why does this case matter? It shows that labels don't control, conduct does. You can call a document a letter of intent, agreement, or anything you like, but what matters is whether the parties objectively showed they meant to be bound right now, and whether the terms are definite enough to enforce. So if someone says, "Don't worry, we'll sign the real contract later," remember Cochran v. Norkunas. Until there is a clear intent to be bound and complete essential terms, you may still be in the world of negotiations, not contracts. Thanks for watching. If you found this interesting, please follow along for more. See you on the next episode.